Hi guys, welcome back to my channel. This is Fopefoluwa. My name is Mofoluwawo. Thank you so much for stopping by the channel once again. Today we want to talk about a very important aspect of litigation. So if you're a litigation lawyer, if you're a layman, or if you're a law student, this will be very helpful for you. Please stay tuned and make sure you watch till the end. And if you haven't subscribed to the channel up until now, please kindly press the subscription button and click the notification bell as well so that you know when I drop a new video. And please, like I always say, leave me comments in the comment section, and if there's something you need to address further or contact me personally about, please mail me at houseoflivingstones@gmail.com, and I will always respond to you as soon as possible. Don't forget to share the links to all the videos as you watch them as well, so that we can build a strong community discussing law on this channel. Today we're going to be talking about examination in chief, cross-examination and re-examination. I know that especially for law students, this is a very crucial aspect of your studies. It's a very important topic. Trial is a very important topic. These are the most important aspects that you need to understand. I'm hoping that you will get that understanding as I explain what trial means, vis-a-vis examination in chief, cross-examination and re-examination today. So let's get right into it. You can find what I'm talking about in section 214 of the Evidence Act 2011 downwards. That's the section that talks about trial, especially about examination in chief, cross-examination and re-examination. Examination in chief is the first stage. Now, if it's a criminal litigation, you know that it opens with arraignment. I've done a video on arraignment. I'll leave the link to it in the description box. Make sure you watch it if you haven't, or if you want to refresh your memory, you can also rewatch it. So criminal litigation starts with arraignment. After arraignment, examination in chief by the prosecution, then cross-examination by the defense, and then re-examination by the prosecution for all prosecution witnesses. And then the defense will open its own case by calling its witness, that's defense witness DW1, 2, 3, as many witnesses as possible. So we have examination in chief by the defense, cross-examination by the prosecution, and then re-examination by the defense. That's for criminal litigation. And after that, the defense closes its case and a date is set for adoption of written address, and the case progresses. Written addresses are adopted and a date is set for judgment. At judgment, we have the conviction, and then the allocutors, and then the sentencing, after which the defendant is entitled to appeal the judgment, or the judgment is executed. That's for criminal litigation. But for civil litigation, we have trial starts by way of examination in chief. So the plaintiff or the claimant, as the case may be, calls their first witness. That's the claimant witness 1. They call all witnesses and they start with examination in chief, cross-examination by the defense, and re-examination by the claimants. They progress with all witnesses like that, and then they close their case. And then the defense calls their own witnesses. They open their case by calling their own witnesses, and then the claimant cross-examines the defense witness, and then the defense re-examines their witness if need be, and then they close their case, and then they fix a date for adoption of written address. Written addresses are adopted and a date is fixed for judgment. And then after judgment, the claimant or the defendant may or may not appeal the judgment. So that's how cases progress, whether they are criminal or civil. But today we want to talk about that aspect of trial that goes by examination in chief, cross-examination and re-examination. It is the fulcrum of trial in Nigeria and in most countries of the world, in most legal systems. This stage of trial is very important because that is when both parties get to present their case to courts, so that the court can adjudicate and decide on the matter. So this stage of trial can make or mar your case in court. So pay full attention, whether you're a litigant, whether you're a claimant, a defendant, whether you're a lawyer or a layman or a law student. This will be very helpful for you. Like I said, it can be found in section 214 of the Evidence Act going downwards. So let's start with examination in chief. Examination in chief is the stage whereby the party that has brought the matter to court, usually the prosecution in criminal cases or the claimant or plaintiff in civil cases, calls their first witness. So the witness is put into the box and is sworn on oath, and then the party that called the witness begins to question his or her own witness. That is what we call examination in chief. It is used to elicit information that is favorable and supporting to your case, from your own witness as a claimant or a prosecution. Usually, examination in chief takes the form of telling a story. So you're supposed to lead your witness to tell their story, how the case happened. I know that I've done a handful of videos. I'll try to link them in the description box on how to open trial, the questions that you need to ask. But let's say that you were in either civil or criminal trial. You start with the WH questions. That is who, what, where. Who are you? What do you do for a living? Where do you live? Those are the questions that you open with before you begin to guide your witness to tell the story. So for instance, I have a witness here. So I'm going to ask her the 3 WH questions and she's going to answer. So we have started. What we want to do now is examination in chief. So for please, I have my claimant witness 1, that's CW1. I am the claimant in this case. So I'm going to start. She's my witness. So I'm going to start to elicit information from her by the 3 WH questions. So witness, tell this honorable court your name.
My name is Precious Babalola.
What do you do for a living?
I'm an entrepreneur. I sell footwears.
Where do you live?
I live at number 5, Peace Close, Aja, Lagos.
Good. So those are the 3 WH questions. For instance, this is a wrongful dismissal case. You ask a question that will then begin to cause the witness to tell the story of how everything happened that brought them to court. So you can say something like, cast your mind back to the 10th day of January 2020. Do you remember what happened on that day?
Yes.
Can you tell this honorable court what happened on that day?
Yes, I can.
Please proceed. So now you can go. That is how to cross-examine your witness, okay? You first ask the 3 WH questions and then you ask a question that would link them to the story of how they came to court and what happened that brought them to court. So that's how to do it, okay? So that's examination in chief. Now note that your main aim is to elicit stories, information from your witness. So it's more like you're guiding them. Don't allow your witness to go on a frolic of their own. They cannot tell all the story in the world because the court does not have all the time in the world. So guide them so that they stay within the precepts of what you filed or front-loaded. There are a few things to note or caution yourself about an examination in chief as a witness or as a lawyer. And one is that you cannot ask leading questions. In examination in chief, you cannot ask leading questions. Leading questions are questions that suggest their own answers. So for instance, you cannot tell the witness that, okay, were you fired by Mr. So on the 10th day of January 2020? That's a leading question. Instead, you can ask them, tell this court what happened on the 10th day of January 2020. So there are so many ways to kill a fowl, okay? And there are so many ways, to skin an antelope. But you cannot ask leading questions, but you can phrase your questions in all manner of ways and forms that will enable and encourage your witness to tell the whole story as is in the statement of claim and in all your processes before the court. You can use open questions. Open questions are highly encouraged. Open questions are questions like, cast your mind back to so and so. Do you know this person? Do you know the person in the defendant's do you know the person in the dock, if it's a criminal matter, for instance? Maybe your first witness is a police officer. You have asked them their name, what they do for a living, their force number or AP number, and when they joined the force. And then you can begin to ask, do you know the defendant? So they will look at the doc and then they will say yes. Then you say, how do you know the defendant? They will start to tell the court how they conducted investigation. Maybe someone filed a complaint and then they made arrests and then they conducted investigation, investigated an alibi and so on and so forth. But essentially, you ask open questions, questions that allow the witness to tell the story and not closed questions or leading questions. Then you cannot also ask a witness about their opinion on the matter because it doesn't count. Hearsay evidence is not also allowed. So do not ask questions that will elicit hearsay evidence, opinion evidence, and all those things that do not matter. You can also make use of closed questions, and you can also make use of transitional questions. For instance, the witness has told us that in 2019, he was employed by Nigerian Limited. Then you can then ask what then happened after that. Did you resume this employment? Those are transitional questions. You are linking them to the next point from the last point that they've said. So you can also ask or use transitional questions. So at this juncture, we are going to make a brief foray into the subject or the idea of leading questions so that we can understand better. Leading questions are questions that suggest their own answer. You can look at that from section 221 of the Evidence Act. It clearly prohibits leading questions at the examination in chief stage. You can ask leading questions in cross-examination stage, but at this first stage, examination in chief, you cannot ask a leading question. A leading question is a question that suggests its own answer. A question that the witness has no leeway to either turn to the left or the right. They essentially have to chorus back to the court what you have said or what you have put in their mouth. So you cannot ask a leading question. Although for certain matters, leading questions are allowed. For instance, for introductory matters, such as when I ask the witness their name, what they did for a living, those are introductory matters. Those are questions that introduce the witness to the court. So you can ask such leading questions. What do you do for a living? It's a leading question. What is your name? It's a leading question. Or maybe you're adopting the witness statement of claim and then you ask the witness, do you want the court to adopt these statements as your evidence in this matter? It's a leading question, but it's allowed. And then you can use leading questions for matters that are undisputed. For instance, this is a wrongful termination case, the example that we have used. So the issue of whether my witness is named Precious Williams or not is not the matter before the court. So I can ask a leading question in that wise. Matters that are undisputed before the court, you can ask a leading question on them. But if, for instance, the matter to be decided by the court is the subject of the witness's name, you cannot ask leading questions regarding that. Or if the dispute is about their witness statement on oath, for instance, you cannot now say, do you want the court to adopt this witness statement on oath? Rather, you say something like, what do you want the court to do with this witness statement on oath? That's an open question, and then they can answer as they please. So leading questions are allowed in instances where there are no disputes about what you're asking questions on, or where there are introductory matters. Now, note that if you ask a leading question, or a party asks a leading question during examination in chief, and the other party does not object to it, the court can act on it. So the court is not the Father Christmas. We always say that whatever you do not ask of the court will not do. So if someone has asked a leading question where they are not supposed to do so, make sure you rise up as the other counsel and object to it. Else, the court will act on it. Also, leading questions can be asked in matters that have been sufficiently proven before the second stage of examination is the cross-examination stage. At this stage, the other party, the party other than the party that called the witness, is allowed to question the witness. And usually, they question the witness to discredit the witness's evidence, or to point or pin out holes in the witness's evidence, or to contradict the witness's evidence, or to try to establish their own case through the other party's witness, or to weaken the other party's case under cross-examination. So these are the importance and the uses of cross-examination. Now, cross-examination is very crucial. So it might be fatal to your case if you do not conduct cross-examination in a matter, because that would mean that you have admitted everything that that particular witness said in examination in chief. So it's important for you to cross-examine if need be, because also if the evidence that the witness has given during examination in chief is not very fatal or crucial to your matter, if it does no harm to your case, you need not cross-examine. But if it does harm to your case, not cross-examining can be very dangerous for you as a opposing counsel, as the opposing counsel or the opposing party. So you find the provision for cross-examination in section 214 of the Evidence Act. It essentially states that the cross-examination is examination carried out by the party other than the party that called the witness. So if I'm claimant and I've called my witness and I've examined them under examination in chief, the defendant can now cross-examine them Okay, and if I'm the defendant and I've called my own witness as DW1 or 2 or 3 or whatever, the claimant or the prosecution can also cross-examine them. So it goes both ways. Now, where there are more than one defendants, each defendant must be allowed to cross-examine the prosecution's witness, and they must also be allowed to cross-examine other defendants' witnesses as well. I hope that is clear. So once the witness is not from you, even if there are several defendants in the matter, once the witness is not from you, you have a right to cross-examine that witness, whether it's coming from a co-defendant or it's coming from the prosecution or it's coming from the claimant. You have a right to cross-examine that witness. Compared to examination in chief, cross-examination is wider in scope, and some have said that it's the scope of cross-examination is as wide as the sky. That means that you can ask as many questions as possible. It's not limited or restricted by the so many rules of examination in chief. So you can ask leading questions during cross-examination. You can ask all sort of questions, but take note that admissibility is governed by relevance. Make sure that whatever question you are asking is eliciting information that is relevant to your matter. Do not try to weary out the court with unnecessary questions and time-wasting questions. Okay, you can ask as many questions as possible, but you do not have to necessarily do so. Okay, just limit your questions to questions that will elicit relevant information that is helpful to your matter from the particular witness you are cross-examining. I know that I was in one trial once, and one of the counsel, I think one of the defense counsel, only asked about 2 questions during cross-examination. He just said, "Witness, do you know the defendant? Do you know the second defendant?" He said, "No, I don't." "Have you ever seen the second defendant before today?" He said, "No." And he said that would be all for the witness, because the evidence that that particular witness had given in examination in chief did not link his client, that's the second defendant, to the case or the charge at all. So there was no need, going on a wild goose chase. There was no need wasting the time of the court. He just asked 2 questions. "Do you know him? Have you seen him before?" He said no. So there's nothing from you, from the evidence you've given so far, linking him to this matter. That will be all. So he rested his case, and then the trial proceeded. So you need to be smart about cross-examination. You need to learn to ask the right questions that will elicit information that will either discredit the evidence that that witness has given against you, or that will establish your own case through them, or that would weaken their case. But do not waste time on unnecessary questions. Also, the law prescribes insulting and abusing, scandalous questions. You cannot ask those type of questions under cross-examination. You can also ask questions to test the credibility of the witness, to establish if that witness is a witness of truth. For instance, if the witness has denied owing, maybe in his evidence in chief or examination in chief, he denied owing monies, which your case is that he actually owes the money. I'll give an instance. For instance, the witness has said that I do not owe the defendant anything. So now I, as the defendant counsel, I'm saying, I can say something like, "Witness, you owe my client, or you owe the defendant 50 pounds. In responding, if he's not a careful witness, he can say something like, "I only owe him 10 pounds. By saying that, he has admitted that he actually owes, even though the figure I put is not the figure he owes. And he has also told the court that he's not a witness of truth, because he had earlier said that he did not owe anything at all. So do you understand? Cross-examination is for you to, test or to disprove the veracity of the witness's testimony as far as your own case is concerned. And Section 223 of the Evidence Act also says something about cross-examination being an opportunity for you to find out what kind of person the witness is, what kind of person he is in life, his station in life. And also, it's an opportunity for you to discredit the witness's character, so you can impugn his character, all in a bid to establish your own matter or discredit him before the court. But you need to be careful when doing this, so that you do not insult, abuse, or scandalize the witness or the court as a whole, because such questions are against, the spirit of cross-examination. To facilitate cross-examination, you can ask probing questions. Those are questions that seek to elicit information, original information. Like the example I gave the other time, you can say, witness, have you ever seen the second defendant? That's a probing question. You're asking him and you say no or yes, I've seen him before. No, I've never seen him. Now, you can also use insinuating questions. You can say something like, are you saying that you knew the second defendant before today? Are you saying that you've seen the second defendant before today or before this case came up in court? So that's an insinuating question. You are suggesting, to the witness. And you can also ask confirmation questions. You can say something like, if I hear you correctly, or if I heard you correctly, what you have said is that you knew the defendant before today. And then you will say, yes, I do. No, I do not. That's a leading question, and that's a confirmation question. You can use it in examination. You can use it in cross-examination. I have 10 commandments of cross-examination here. So I'm just going to list them one after the other. They will help you. You can take them down and practice them. The first is that be very brief. Don't ask long and windy questions that will end up confusing the judge or confusing the defendant, or questions that will end up confusing the witness or the court. Do not ask those questions. Be very brief and succinct. 2, avoid open questions as much as possible. I say you can use open and closed questions during examination in chief, but for cross-examination, use more of closed questions, not open questions that allow the witness to, go on a traverse. No, use closed questions more. 3 is that review your questions, okay? Review your questions. So you can, if you ask the question, you can say, what I'm saying is, then you say it again, couch it in a clearer form before you allow the witness to answer. That's 3. Then 4, do not ask a question to which you do not also know the answer. Very dangerous and very dicey. It can land you in trouble. Make sure that every question that you are asking, you have preempted the witness's answer before you ask such questions. 5 is that make sure you pay attention to the answers the witness is giving. Don't get carried away asking questions that you don't pay attention to the answers. Don't forget that the court is writing, and it is the court's record that would go into judgment. So you must be very careful as you're asking questions. Make sure you are listening to the answers. 6 is that once the witness has said what you want them to say, once they have given the answer you want them to give, please stop probing. The 7th commandment is change your style. Avoid being stereotyped. So make sure that the witness cannot preempt you or preempt you too much. So make sure that you keep changing your questioning style every now and then, okay? The 8th commandment is do not give the witness an opportunity to repair their testimony. So if, for instance, the witness has lied, and in the process of answering your own question, they realize that there are discrepancies in their testimony, make sure you cut them short as politely as possible. Do not allow them to use your cross-examination to repair their testimony. Very important. And the 9th commandment is do not give your witness an opportunity to explain himself or herself. Okay, so here's an example. Witness, tell this honorable court how many plots of land you inherited from your grandfather.
I inherited 4 plots of land. My brother inherited 3 plots of land, and he gave my sister 2 plots of land. Actually, in the
witness, what I'm asking you is, you in particular, how many plots of land did you inherit from your grandfather?
I inherited 4 plots of land.
That's okay. So that's how to cut the witness short. Limit them to the scope of the questions that you're asking and the information you're trying to elicit from them. The 10th and most important commandment is do not ask too many questions. Sometimes even the judge is tired of writing. Sometimes even the witness is lost, or other parties, other lawyers or opposing counsel becomes lost or even disinterested, which might not be to your own good. So please do not weary out all other parties in the matter, all other stakeholders. Make sure that you only ask relevant questions that are as well admissible. So those are the 10 commandments for cross-examination. If a witness has made an extrajudicial statement that is already before the court, and during oral evidence they are contradicting that statement, the court should take their evidence with a pinch of salt. That is, the court should not attach much weight to such evidence, and it behoves on you as the adversarial counsel, especially in a criminal matter. It behoves on the defense to actually call attention to those discrepancies by tendering the extrajudicial statements of the witness, because the prosecution does not have to tender their witnesses' statements, but you can tender it, through the witness, so that you can call attention to the discrepancies in the statements, written statements, and the oral evidence given by such witness, so that you can discredit such witness before the court. The last stage of examination is re-examination. Re-examination, as it suggests, re-examination is conducted by the party that called the witness. After the other party might have cross-examined, then the original party gets to re-examine to shed light on parts of the evidence that might have become, a little shady, just to clear ambiguities. Now, re-examination is not compulsory as well. Usually, most people just say NIL, that's NIL, when they are asked to re-examine their witness. And that means that there's no ambiguity in the cross-examination that they need to clear. So, you do not have to use this opportunity if it is not necessary. Just don't worry the court and don't worry the witness, and don't spoil your own case, And the re-examination is not for introducing fresh matters. In fact, if you try to do it, the court will call your attention or the other party will object to it. So it's not an opportunity for you to introduce fresh matters through your witness. Rather, according to Section 214 of the Evidence Act, it's just to clear ambiguities that might have come up during cross-examination. And that is how examination is conducted per witness. Then you tell the court that that's all for the witness when you are done. I did a video on this too. Many people forget it. After telling the court that's all for the witness, you ask the court to discharge your witness, and then you call the next witness. Or if you're done, you tell the court that's the case for the claimant, that's the case for the prosecution, that's the case for the defense, so that if there's another party that wants to call witnesses, they can proceed. So that's how examination is carried out. You can look at sections 214 of the Evidence Act through section 221 or 224 thereabouts. Those sections talk about examination and oral evidence in court. So make sure you prep your witness ahead, very important, and make sure that you limit the scope of questions, whether you are on cross-examination or re-examination or examination in chief. Limit your questions to questions that will elicit relevant information that will strengthen your case and discredit or weaken the other party's case in examination. So that's all I have for you in this video. Thank you for watching, and appreciation to my two witnesses. I will see you in my very next video. Toodles.